do you have cause to fault any of them in the way they enunciate the law?
Good morning once again to Sammy and Senior. I have had the opportunity to read the judgment, I would say almost twice. The beauty about it is that you will notice that both the dissenting opinion and the majority all agreed on the issues for determination. 2, they almost all agreed to the facts. 3, they almost all used the same authorities, case law and statute. 4, the evidence that was led was what all of them relied on. 5 is that their conclusions were different. That is the beauty of the law. And each judge supported his reasoning with the authorities. Now, if you look at the lead decision by the majority, you would see that, like you rightly said, he didn't limit his analysis to only criminal law, criminal law. For example, he analyzed the grounds of appeal, and that is where a lot of the discussions have lost sight of. It is not all the grounds of appeal that the appellants filed that were upheld.
About 5 or so.
He struck them out, relying on the
briefing. Yeah. Sammy, were you sitting in the court?
When they
were delivering the judgment?
No.
Okay.
But I'm told that the judgment was not read.
Okay.
They just read the introductory
and the
points
effects
and the conclusion.
Okay. So this is the kind of judgment that when you are sitting in the court, even as a lawyer, you are not too sure what's going to happen to your client until you get to page 30. Then you begin to see your way clear as to where the judge who is reading is going. But even that is only one judge. So you are not even sure what the next will do. So if you are not careful, you'll be in trouble. Okay, go on.
So I think they did an extensive job. Like I was saying, he used the rules of the grounds of appeal.
Right.
That I thought is limited to only appeals in civil matters, to set aside or strike out the grounds of appeal, even though it was a criminal matter. That is an interesting approach by the judge, because if you take the Court of Appeal rules, there's the part 1 that deals with civil appeals, and the part 2 that deals with the criminal appeals. And you do not see the Rule 8, as he discussed in the civil appeals, being repeated in the criminal appeals. So, but unfortunately for us, we will not have the benefit of having this approach by him in respect of the grounds of appeal tested, because the appellants won at the end of the day. And so it doesn't matter how they won. Once their most important grounds of appeal, being that the decision by the trial judge in March 2023 was unreasonable compared to the evidence that had been supported, and everything else falls under it. And so I would say that irrespective of how you look at it.
Isn't that how the judge intelligently handled it? After striking out all the others, he came on that omnibus one and was able to deal with the issue.
There were two, not just the omnibus. The omnibus, which is actually the central ground, for any appeal, that the evidence is against the weight of the judgment. And those he dismisses them on the grounds that, by law, when you say a judge has erred in law, you must particularize the error. If you say they have erred in fact, you must particularize the facts. But here they just said erred in law, they didn't state the particulars. And you say you disagree with that? That should only apply in civil and not criminal?
I'm saying that all the analysis and the authorities he used were in respect of the rules on civil appeals.
Okay.
Honorable is here. If you take the criminal appeals, you do not find those rules there. And so, taking it, because we know that in a judge exercising criminal jurisdiction will not necessarily have the right to make determination when it comes to civil. So it was an interesting thing. I'm not saying he's wrong, but that was the first time that I have seen that in purely criminal matter, the rules that apply to civil appeals were being used strictly to strike down grounds of appeal. So imagine that even though they say appeal is by way of rehearing, imagine that the appellants did not have as one of the grounds of appeal that the judgment was against, is unreasonable as related to the evidence that had been led. It means that the appeal
would have gone.
Exactly. And so you see that he took his time to actually go through everything step by step. Okay. And the way he narrated the facts from the beginning of the judgment made it very easy for you to situate his analysis in that context.
Okay, so because you have begun from there, let me restate here. There were 6 grounds of appeal. The majority began the decision by dismissing 4 of the grounds and upholding 2 of the grounds. The grounds that were left on the basis of which this whole judgment hangs are these. The court violated the right to fair trial of Atuforsen when it disregarded evidence in favor of Atuforsen. And then finally, the court erred in shifting the burden of proof on Atuforsen to prove that he had the authorization of the Minister of Finance to request the Bank of Ghana to set up the letters of credit for payment of the ambulances. Right, now get to the meat.
Whether I agree with the decision?
Yes.
Apart from where I said I wasn't sure whether you could apply the rules of civil procedure to strike out grounds of appeal in a criminal appeal, I think essentially I do not find a reason to dissent from the decision by the majority. Because the way he set out the charges, you see that the elements that he was expecting the evidence to be adduced of were not met at all. If you read the count 1, I don't know if we would have the opportunity to read it, you would see that the way the Attorney General set it out, you would expect that the facts or the evidence that will be led will meet these ones. You mentioned one of them, and that was at the tail end of the charge, the particulars of offense. You see that it says that count 1, that the statement of offense was willfully causing financial loss. Now, the particulars of offense is what you are telling the accused person that you would adduce evidence in support. Now, if you read the particulars of offense, you, Castle Atuforsen, between August 2014 and April 2016 in Accra, in the Republic of Ghana, willfully, now willfully means they must connote the mensura, the intention there, caused financial loss of 2.37 million euros to the Republic by authorizing irrevocable letters of credit. Now come to the end. Without due cause and authorization. And so 1, you must be able to prove as a prosecution at the end of your case that Mr. Atuforsen had the intention. The intention to what? That at the time he was authorizing the payment, the vehicles were not fit for purpose. That is the first proof, that at the time he was authorizing the LC, the vehicles were not fit for purpose. 2, you must be able to prove that he did not have the authority to authorize the LC. And so if you come to court and then your evidence shows that 1, he was only playing the role, and that is essentially where the court started from, in his official capacity as the Deputy Minister for Finance, and that he was not responsible for the contract. He did not play any role in the contract, not before, not after. 2, that the LC was not payment. And you see the judge dwelling on that LC, and when the former Minister for Health was cross-examined, even though initially he said no, eventually, yes, he said yes, LC is not payment. That the wording of the LC was very clear, that if these conditions are met, now whose responsibility is it to make sure that the conditions are met? That is why the judge said that responsibility lies with the Minister for Health.
Right, that Atuforsen wrote requesting urgently that letters of credit should be established for the contract sum. And the witnesses that are called by the Attorney General are almost all in agreement that the LC is not payment. It has conditions. And you're saying that, as the court found, the one to ensure that the conditions are met before payment is triggered is Ministry of Health and not the Finance Ministry.
Yes, and not the Finance Ministry.
Okay.
And the second most important thing is whether or not he had the authority. And as the judges said, the majority, if you assert that he did not have the authority, you must provide something from the person who ought to have given him the authority, so that the burden will shift on him. If you have not provided that fact that he did not have the authority, he had no burden to show or to demonstrate that he had the authority.
That was why the judges said that the person who would have given that authority or not given that authority is Mr. Setepe.
Right.
And that the burden was on the state to provide evidence from Mr. Setepe, either in writing before, during, or even after, that I did not authorize you or I have not authorized you.
Or that they ought to have called Setepe and put him under cross-examination. And that even when Setepe offers himself, they don't cross-examine him on the issue. Because he's the only material witness to determine whether or not he authorized Atoforcing or he did not.
Yes.
So to the extent that the authorization letter says, I'm writing for and on behalf of Setepe, and he does so, the one responsible is not Atoforcing,
yes,
but the minister.
Yes.
And you didn't call the minister.
You didn't call
when
the
you
minister.
had the opportunity, you didn't also cross-examine him on that issue. Therefore, you have failed. That is how come that issue also failed.
Because the judge relied on, like you said, the presumption in the Evidence Act that official duties are presumed to have been regularly done. And so once official duties are presumed to have been regularly done, the burden shifts on the person claiming otherwise to establish a prima facie case that it was not done. Now, if you look at Mr. Jakpa, his was, I think, quite straightforward. That he was only an agent, not a principal. And basic law is that once the principal is disclosed, you do not fix liability on the agent. 2, Mr. Jakpa was not a party to the whole contract. 3, the state never paid any money directly to Mr. Jakpa. Mr. Jakpa, sorry, I said Seti Jakpa. Mr. Jakpa actually went to court. He sued his principal that have done work. We had agreed on 28% or so commission. You didn't pay me. And so I don't know whether he garnished the government, but there seems to be that because of that was the Attorney General's case, that he had pocketed money from a transaction that he thinks was vitiated for all the reasons that had been disclosed. So I think if you analyze the evidence the way the majority did and apply it to the facts and the law, I would find it difficult, except my
okay.
Not sure
so
about
I'm coming to the two politicians, but of course also lawyers. But before we do so, do you hear the judge, the majority saying that, dear state or attorney general, you actually have the opportunity to recover your money if you really think that your almost 4 million euros is lost, because the people you should have pursued, you didn't pursue them. You ought to have pursued Big C. That's the principal. And you ought to be pursuing the Ministry of Health and not the Ministry of Finance. The Ministry of Health, there was a director.
The chief director, I think.
Who the state put a nolli prosequi and got him off. So he wasn't prosecuted. Do you think there's still opportunity for the state to go after perhaps Big C or whoever it is in civil recovery?
And I don't know why that has not been done. Because as the judge rightly said, as we speak now, the ambulances are there. And the evidence adduced was that Big C had written a letter acknowledging the defects and saying that we will send technical men to remedy it. It was they said there was an expert opinion from Silver Star also that said that the vehicle itself was not meant for that purpose. It means that Big C from the beginning has misrepresented the quality, the fitness, and once Mr. Segbefia at that time, immediately the ambulances were collected, wrote to Big C. He had satisfied all the conditions, except that I have not had the benefit, and I think the judge said it, of the agreement that was signed between Big C and the Republic of Ghana or the Ministry of Health or whichever state agency signed it to determine the ambit of the civil liability, whether or not, since it was in 2014 or 16 thereabout, whether the issues of limitation would fall in play, which law would be applicable. And so that is what, if you don't have the benefit of all of those things, on the face of it, the state would have an opportunity to go subject against Big C, subject to the limitation and whatever the terms of that contract was.
So